All right, so we're going to get started. Thank you all for joining us for this webinar hosted in partnership with Miller and Martin. And the webinar is the Families First Coronavirus Response Act. I will open the floor to Chris Parker, who is actually on the line with us.
Good afternoon, everybody. Thanks for joining us today. Thanks to you and the German American Chamber for sponsoring this and helping us get this information out to everyone. I appreciate everybody's time. I know a lot of us are running in circles right now trying to adjust to a new and hopefully somewhat temporary reality. I know many of our organizations have spent a lot of time and energy on different ways of trying to cope with the situation that we now have, and to the extent we can all do that with a sense of humor and optimism, certainly that helps. If you could go to the first slide, Thais. I will apologize. The way we are set up, Thais is controlling the slides for me from a different place, so I may have to prompt her on occasion. To start with, I assume everybody on the line is aware that we're having a new part of our daily dialogue that focuses on coronavirus, also known as COVID-19. That is a very significant intrusion into our work and personal lives. The slides we're looking at right now is a map that is quite frankly now dated from Johns Hopkins, trying to show the spread of the outbreak. This changes. I will commend very highly if anybody is looking for statistical, more medical information on COVID-19. I will direct them to the Johns Hopkins website on that. They keep a relatively real-time world tracker with all sorts of great information on it as to where hotspots are and reported cases are. Okay, next. Next slide, please. Yeah. As we all know, I am a lawyer. I've been practicing for 31 years. A significant portion of it has been devoted to labor and employment issues. Because this is a discussion involving a lawyer talking to others, I got to give you a few caveats, unfortunately, right up front. First and foremost, well, I hope you find this to be useful. This is not intended to create an attorney-client relationship, and I'm not providing anybody with individual legal advice. That's a fairly typical one. Now, here to something that's more meaty. What we're going to be talking about today is a very new statute, and I can say with no hesitation, the law that we are talking about is changing almost hour by hour, but certainly day by day. The laws that we're talking about have regulations that have yet to be promulgated. Things are still very much in a state of flux and change. We are receiving periodic rollout press releases and communications from the U.S. Department of Labor, the IRS, and other agencies on different parts of these packages that are refining, changing, altering our analysis on certain issues in certain ways. So what I am giving you is the information I currently have at my disposal. I will say I think it is probably 95% correct. Well, I think it's correct as of now, but 95% of what we will see at the very end of things. This is almost reminiscent of 9/11 in some ways, in that most of us are sitting in front of TV sets all day watching news crawlers. As we're sitting here today, the Senate has passed a large stimulus bill that touches on some of the issues we're going to discuss today. The House has to take that up yet, so it is not a law. I will make some references to some things that we believe are going to come out of the stimulus package. Those things are even more speculative because we're not exactly sure what that is going to leave us with. Overall, what we're seeing is the purpose of the Families First Coronavirus Response Act, and I'm generally going to call that the FFCRA today, is a law intended to provide some compensation for people who are for employees who are directly affected by the current pandemic, and it imposes some new obligations on employers. Next slide, please. Okay. Thais, can you hit the next slide?
Yep.
Yep. So a little background that gets into why. Well, actually, Thais, I'm sorry, I may have told you to go.
You can go back.
Go back one. I'm sorry.
Yep. No problem.
I've got multiple screens in front of me, and they all seem to have a different timing mechanism. I apologize. Okay, so what do we have here? When's this become a reality? This is one of the changes that we saw this week. And the FFCRA is now set to become effective on April 1, 2020. Okay. Originally, when this came down the pipeline last week, the rollout date was April 2nd. That's only a day later, but some employers have been planning on that April 1 date. DOL's communications have indicated that it will begin its enforcement efforts, or they will presume that this is effective as of April 1. Now, a little more background on this in terms of the expediency, and this was the prior slide. We don't need to go back, but I'll go over it. This is a law that was created in 5 days, okay? In reality, it was probably created in about 3 days in the House because the Senate was unable to make any changes and still have it passed. I'm not aware of an employment law that has imposed paid leave on an employer in U.S. society that has had such a short legislative history. In effect, there is zero legislative history. I am also not aware of a law with such sweeping changes, at least in my 31 years. It was rolled out without any regulatory guidance prior to its effective date. Back in the early 90s, some of us may remember when the Americans with Disabilities Act came into play. That was a very sweeping change to U.S. civil rights laws. In the time frame leading up to and surrounding the rollout of the ADA, I probably gave 45 to 60 full-day and 2-day seminars on how the ADA was going to impact employers. We had a very thick notebook of regulatory materials at our disposal that we could pull from. We don't have that on this occasion. Now, these are generally amendments to the Family and Medical Leave Act, so we can look at some of that regulatory framework, but it is very different in terms of how this is going to apply to this specific situation. And the regulations that the DOL has promised us for next week very well may change some things going forward. Okay, if you go to the next slide, please. Okay. Okay, so first and foremost, what is the FFCRA? Okay, and I'm not going to spend a lot of time today talking about the names of these different statutes because, quite frankly, they are a little bit confusing. But I'm going to divide it up into the way that Congress did. And there are 2 statutes that we're going to look at. One is, or sub-statutes, if you will. There is the Emergency Family Medical Leave Act Expansion Act, the FMLA Expansion Act, and there is a Paid Sick Leave Act. So they both are going to fall under the FMLA, but they're going to have different requirements and impose different obligations. The way this was rolled out with the original House bill, which was subsequently amended and became the final bill, kind of where these things appeared and what some of the obligations have shifted around. So I'm going to try to walk you through functionally, what does this mean to your business? How do you follow this? Okay. The overall intent of this new law, go ahead and go back if you would. Okay. The overall intent is to provide assistance to employees who are impacted by the pandemic. Okay. What we're going to see is more employees and employers are covered by this than they are under the FMLA. The law it is amending. And now, for those of you who are familiar with the FMLA, it is always unpaid leave. This law specifically has compensation requirements for employees in it that are brand new. Okay, next slide. So since the FMLA came on board in roughly, I think it was 1993, almost every year there has been a bill introduced to make it paid leave and or expand it from 12 to 16 weeks, and that generally gets voted down every year. In the course of 3 to 5 days, Congress now agreed that we're going to have some pay requirements. Now, this law that we're talking about sunsets or goes away at the end of this calendar year. Whether some form of this is extended in the future remains to be seen. Because of the financial ties into the government funding on this, I have some doubts about that, but let's talk about what it does now, okay? Under the Emergency Paid Sick Leave Act, okay, this is a 2-week paid leave provision, all right? And the easiest way to divide this up functionally in your head is there is paid leave that is provided at one monetary level, and I'll go through it, for employees who individually are receiving treatment for coronavirus, or they are being quarantined by a doctor or a government because of a coronavirus scare. So if you've come in contact with somebody who has tested positive, doctors are telling you to, quarantine yourself for 14 days. If you are ill because of presumptive or proven coronavirus symptoms, then you are being quarantined for 14 days for treatment, okay? If you have to care for someone else who is subject to a quarantine order, you're getting a 2-week window of paid leave, okay? The other aspect of this paid sick leave, and the Paid Sick Leave Act is a 2-week statute, okay? It provides for 10 days or up to 80 hours of paid leave, and that's 10 work days, but it's got an 80 hours cap, and I'll go through the payment requirements here in just a moment. So it's a 2-week window where someone's sick, caring for somebody else, where they have to be at home and are unable to work because they have childcare unavailable or because schools are closed. So that school closure issue is probably the most widespread impact at the moment, okay? Let's go ahead to the next slide. So the other component of this is not the sick leave portion, but it's the Emergency FMLA Expansion Act. And this is a much narrower statute that covers a 12-week period, the last 10 weeks of which provide for paid leave. So we're going to talk about, you're going to have to, if you want to have 12 weeks of a paid leave obligation, you're going to have to buttress these two statutes together. The Emergency FMLA Expansion Act is actually very, very simple, okay? It provides 12 weeks of job protection. I mean, you can't fire somebody because they have to be off for this leave or they're claiming it. There's anti-retaliation provisions that will be in this as well. And it's for people who have to stay at home because they've lost childcare or their schools, their children's schools are closed and they are unable to work or telework, okay? Now, a big question that is unanswered at this point is, how do I determine if my employee is unable to telework? I have invested a lot of time and money to deploy computers and laptops and other devices so people can work remotely in this circumstance. I know their kids are at home. I'm asking them to remote work. The answer to that question is, I don't really know at this point. My guess is it's going to be a very liberal interpretation. So if you have an employee with one or more children at home and their schools are closed because of this virus, and if they make a claim that says, I can't even get my work done remotely, they're going to be entitled to leave under the statute. Now, the only thing we're worried about with the Emergency FMLA Expansion Act is this situation where employees have to take care of someone else, their kids, because their kids' schools are closed or childcare is not available, okay? This part of the law does not deal with an individual who has symptoms or is quarantined, or they're taking care of somebody who has symptoms or quarantine. It's really a child care type provision. Okay, let's go to the next slide. All right, now another thing I want you to kind of get your head around right up at the beginning is the FFCRA is a leave that is provided when the leave is needed by the employee for one of these reasons that we're going to talk about further. It does not provide pay or leave because an employer has separately decided to cut back on its operations. So we're obviously seeing a lot of companies that are having to cut back on operations right now for a variety of reasons. Travel, hospitality, restaurants are having to lay off people right and left, okay? If you have an employee who does not have work because the employer has laid them off or furloughed them or told them not to report because we have no customers, that is not covered by this law, okay? Loss of hours based on something that the employer has determined is not covered by these new leave provisions. These new leave provisions only cover things from the employee point of view. So that is an area that we've gotten a ton of questions about, and we're having employer clients who are scrambling around trying to weigh what their leave obligations are and buttress those up with production needs. Just understand that this law does not go into effect until April 1. So it is not affecting the decisions that you're making today. And it does not affect loss of work opportunities at this point that are based on the employer's business needs. Okay. Now, if your business closes or you're having to reduce hours, your employees very well may be able to apply for and receive unemployment compensation benefits. Okay. And I'll talk a little bit in more detail about that a little bit later, but there is a financial assistance that is available to employees when the company has made the determination that we need to reduce workloads. And there's a lot of money in the stimulus package, at least in the current package, and I think there will be at the end, to help fund wage losses as a result of that. Okay, so let's get back to the FFCRA and talk about who all it covers. Okay. All right. Go to the next slide, please. Does this law apply to my business? Okay. This turns things a little bit upside down from the normal FMLA analysis. The normal FMLA analysis excludes smaller employers. This law takes a very different approach. Okay. And again, I've got the bullet points up here talking about the two different provisions of leave that we have. The first being that 80-hour sick leave provisions. That's going to apply to all public entities, and it's going to apply to any private company with fewer than 500 employees. Okay, so it's not going to apply to very large employers. The question we're getting most often is, okay, how do I count my employees? I'm anticipating that the DOL regs that we will probably see next week are going to provide some more insight on that. For right now, the DOL is saying, look at the number of people you have employed in the United States across your business units. Now, they will look at what is, who is an integrated employer versus separate operations. I mean, if you're a holding company that has employees in 20 unrelated businesses, those are likely to not be aggregated. If you were a company with factories or production units in 5 different states that all report up to the same control unit, those likely will be aggregated. Okay. I know a lot of you are going to have questions on, okay, I may be 400, I may be 600, along those lines. We really need to kind of wait and see what the regs are going to tell us in terms of who can and can't be counted, because I think it's going to be a little more expansive than the normal view we take a look at to see who's a joint employer. All right. So that's for the sick leave provisions. Now, the expanded FMLA has the same, basically the same employer coverage requirements. All non-federal public employers. So there's an expansion, there's an exclusion rather, for federal employees from that. And we have similar exclusions in a lot of our civil rights laws for federal employees. And again, they're looking at employers of 500 or less, okay? So again, if you're a very large employer, this is likely not going to be a headache for you at all, okay? Next slide, please. All right, now there are a couple of exemptions or exceptions that may apply here. Or excuse me, there's two, and it's not necessarily, one is for employees and the other one is for employers. When the original bill came out, it indicated that if you had less than 50 employees, you could apply to the DOL for an exemption from from this entire bundle of statutes. The final version has narrowed that down and has said this exemption will be available by application to the DOL, and we do not have any instructions at this point in terms of how the DOL is going to administer this, but it's only for the emergency FMLA leave, that leave for childcare over the 12-week period, okay? There's not, from what we are seeing now, there's not going to be an exception for smaller employers for the sick leave provisions for that 2-week, 80-hour concern. The DOL has told us that regulations on this will be coming out in April, and one of their pronouncements said they hope to have something out next week. Don't know if it's going to be next week or if it's going to be the week after that, which would be the first full week of April. But that's what we know about it at this point. Okay, next slide. All right. Now, you're going to see some slides here that are going to be a little bit, they're going to have a lot of words on them. Sorry about that, but some of these things needed to be grouped together. So let's talk about the 10-day window, okay? And the easiest way, there is a difference in the dollars that are attached to the leave based on why they are needed, okay? If the leave for the paid sick leave is 2 weeks, 10 days of pay, is because the individual employee is ill or has been quarantined by order of a government or by order of a doctor. And just to kind of preempt a lot of questions we're getting on this, you're going to have a lot of folks who are presenting with flu-like symptoms. The way things are working out in the medical community, they are calling their doctor because their doctor does not want them coming in and saying, I have respiratory distress, I have body aches, I have fever. And the doctor's going to say, treat it like the flu. More importantly, treat it like coronavirus. Quarantine yourself for 14 days. Despite what you were seeing in the media, the availability of testing and the ability to get those tests processed is still very compromised. My wife is a hospital nurse, and she has 3 of her coworkers that started showing signs last Tuesday. On Wednesday, they had to go to a drive-up facility in another county, and we are now 1 week later, and we still do not have results from those tests. So even hospital workers are having trouble getting the test processed. For you and I, our doctor is going to tell you to follow these quarantine, steps. So if it's the individual employee and they are quarantined as a result of how they are feeling for that first 2 weeks, they are going to be entitled to paid leave at their full regular wages up to a cap of $511 per day, or a total amount of $5,110. Okay? So if they're sick, they get the largest benefit. If they are going to be out for sick leave because they need to take care of someone else, or because their child's school has closed or their child care provider has closed down, that benefit is 2/3 of their regular wages, up to a maximum of $200 per day. Okay? And again, this is the type of pay that is not going to be subject to a smaller employer exemption. Okay, so if you have 500 or less employees, this is what the paid sick leave is going to look like for you. All right. Now let's look at the next slide, please. For the expanded FMLA leave, where folks can't work or telework because their kids' schools have been closed or their childcare has been closed, they're going to have 10 weeks. The back 10 weeks, the first 2 weeks of that are unpaid, but I just told you in the first slide, they get paid sick leave during that 2-week time. Once that paid sick leave time expires, they have a 10-week window in which they can be on expanded FMLA and receive 2/3 of their wages, up to $200 per day, or a maximum of $10,000. Okay. Okay, let's go to the next slide, please. And okay, let's look at exceptions to employee coverage. I've been talking about employer coverage, which focuses largely on the size and are you public or private sector. There's a little bit of an irony in this to me, but employers of healthcare providers or emergency first responders may elect to exclude those employees from the sick leave provisions. So the people who are busiest right now, first responders and healthcare providers, their employers may elect to exclude them from the sick leave. Okay, can't really explain that to you other than I think Congress is very worried about creating any financial incentive for folks in those categories to not come to work. Okay, and as I indicated before, the statute says the DOL will be issuing some regulations which exempt employees on this longer, basically child care leave if you have less than 50 employees. Don't exactly know what that exemption criteria are going to be, but smaller employers may not have that liability. Okay, next slide. And this is another detailed slide. Again, I apologize for that, but it lays some things out in the terms. The statute has done it and breaks out the reasons for different types of leave. Okay, and this slide looks at, and by the way, FAIS, I believe, will have the ability to allow all of you to download these slides at the end of the presentation.
Yes, that is correct. And sorry to jump in. I see all the questions coming in. We're saving questions to the end, so we are not ignoring. We're just saving all the questions to the end.
Okay. So, and the only thing I will say, if you're looking at these slides later, just please do remember some things may change in the next week. Okay. I've tried to structure these based on what we know now and things that we think are going to persist, but this could get tweaked a little bit. Our firm has a website with resources on it. You can always refer back to that. There'll be a tab on there and it'll direct you to some different things. Okay, so what are the different reasons that qualify you for these types of leave? I've talked about them in general terms. Here's how the statute lays it out if you want to see it in specific detail. This first one talks about the paid emergency sick leave. That's the 2-week, 10-day leave for which employees can either get, if they're sick, their full wages up to $5.11 per day, or if they're caring for somebody else or their child's school has closed, they could get 2/3 of their wage and up to a maximum of $200 a day. All right. So these 6 factors are how this is playing out, how the statute is dividing it up. 1, if the employee is subject to a quarantine order from the government. 2, their doctor has told them to self-quarantine. 3, they're experiencing symptoms and are in the process of trying to talk to their doctor. Okay. And 4, this is caring for some. So those first 3, that's going to be the higher amount of pay that goes along with it. as is number 4. They're caring for an individual subject to an order. So they're caring for somebody else who is sick. Item 5, this is the child care criteria. They're caring for a child whose school has closed or their place of care has closed. That could be a daycare. And when this talks about child, it means a child generally under the age of 18. I would say generally you're looking at birth to typical high school graduation. So if you have a child who is 19 and still in high school, I would consider them to be covered. Doesn't apply to your college students. Hopefully by then they're able to care for themselves, all right, at some level. And then item 6, this is a catch-all we're seeing in the definitions. They don't know what's coming. If we get some substantially similar condition where the U.S. Secretary of HHS, in consultation with Labor and Treasury, has said we're going to extend this, okay? I think that's probably only going to come into effect if they're seeing some residual care issues or economic issues at the end of this pandemic, okay? Now, let's go to I'm trying to put the pieces together for you, so let's go to the next slide. If you look at the prior slide, under reasons 1, 4, and 6, that's where somebody gets the paid sick leave for 2 weeks, 80 hours, or a 10-hour workday. It's capped at 80 hours, okay? If someone is out because of a childcare reason, item 5, they're going to be open for a total of 12 weeks of leave altogether, okay? So how much do I have to pay? This is where we're getting to get into a little bit of the repetition from the things I've been telling you, because I find that when you go over it different ways, people hear it differently. The classic answer I got to give you is it depends. We've got to kind of go through the reason for the leave as I've laid it out and kind of follow the bouncing ball and put the pieces together. So let's stack these in terms of generosity to the employee. The highest category of $511 per day, their regular wages up to a maximum of $511 per day. This is for paid sick leave when the employee is sick. That's how much they get, okay? The next financial step down on the next slide is if the employee is taking care of someone else who is sick, or if they have lost child care, then they get 2 weeks of paid sick leave at 2/3 of their regular rate, or $200 per day. It's capped at $2,000. Okay, these are the 2 paid sick leave provisions. Okay, there's no small employer exemption that's going to be forthcoming for that. The 2 very different financial ramifications for sick leave. Okay, and then let's go over to the emergency FMLA leave, and this is again is focused on the child care side of things. Schools are closed, childcare is not available. It's 12 weeks of job protection, but from a pay perspective, under the emergency FMLA, there's only a pay obligation in the back 10 weeks of that 12 weeks. Why is that? Because in the first 2 weeks of it, they get paid sick leave. After 2 weeks of sick leave, it becomes expanded FMLA, and they can get 2/3 of their regular wage, and this says applicable minimum wage, and that's a typo in this. It's their applicable regular wage, up to $200 per day, or a total of $10,000. Okay, so they're going to get 2 weeks of sick leave at 2/3, and they're going to get 10 weeks of expanded FMLA at 2/3 with the caps that I've talked about. Okay. Some of you have your head spinning. You've been watching the news, you've been reading the news articles, you've been getting inundated with articles from law firms trying to describe this in a number of different ways. What does it all mean? All right. I like flowcharts. Okay, so this seems more complicated, but it's an effort to simplify where people fit in the different buckets. Okay. And it's a yes-no analysis, start at the top, work to the bottom. We're all familiar with flowcharts, okay? Is it the result of an employer closure or work reduction? So this is an employee leave. The company is just shutting things down. The answer to that is yes. Stop where you're at. We don't have to worry about these leave requirements. If it's not, the employer is still operating, then we're going to walk through the different reasons for leave and what those ramifications are on the other side. Okay? And then at the very end, just bear in mind, this is what the paid leave obligations in this new statute are. We still have to look at FMLA, ADA, other leave laws that are out there. Okay, those are all unpaid leaves for the most part, but they're not off the table. This is laid on top of those. Okay. All right, everybody is reaching for their checkbook, trying to empty out their bank account and see if there's some way to get out of the country and to a place that this virus is not touching. Well, relax, the government's here to help you, right? You've heard that before. Okay, so what are we seeing in terms of how the government's gonna help? We go to the next slide. All right, earlier this week, the IRS put out a press release on an employer payroll tax credit that is supposed to help employers pay for this leave. And we're seeing these things come out in dribs and drabs that are expanding and clarifying a lot of the questions that we're seeing. In essence, every dollar that the employer spends on one of these leaves that we've been talking about, the employer is entitled to deduct from their payroll tax bill the amount of that leave. Okay, so if you pay an employee $1,000 in leave, you take $1,000 off your tax credit bill, your payroll tax bill, before you send it in. Okay, so it's immediate tax credit help. It's not wait till the end of the year. It's on your next bill. Okay, and this also allows the employer to retain and not pay to the federal government any federal income tax withholdings, the employee share of FICA and Medicare, Social Security and Medicare, and the employer share. Okay, next slide. Here's some kind of big issues on this that have been rolled out with the IRS. All right, health insurance cost. If you subsidize employee health care and that's part of the leave benefit, the cost of that should be included in the credit. I don't have the final IRS guidelines on what you can and can't do with the employee contribution part, but if you have an employee who makes $1,000 a week and they get a $300 subsidy from their employer on their health employment, you're entitled to a $1,300 tax credit. Okay. So it's not just the cash part of the leave, it's also the benefit part that costs the employer. All right. The leave benefits themselves are not going to be subject to taxes. Self-employed individuals can request a tax credit on their estimated tax payments. Now that's generally going to have a little bit of a delay in the relief to it. And we're going to have to wait and see how the guidelines want that to work. Now the IRS, in their guidance that came out earlier this week, also stated, and this was something new that we hadn't seen, that if the payroll tax liability was insufficient to cover the leave cost, they're going to come up with a mechanism where the IRS will promptly issue a refund. So if your tax bill is $5,000 and you're paying $10,000 in employee leave, the IRS is going to be in a position to refund, send you a check for the $5,000 overage. Again, don't know how that's going to work, but the IRS says that is supposed to it's supposed to happen on a prompt basis. All right, next slide. All right, the statute also authorizes a temporary 6.2% increase in federal Medicaid funds that are going to be available to the states. That's not going to affect you as an employer most directly, but it's going to put more money in the state coffers. A lot of companies are using respiratory devices, generally N95 masks. Those are the only ones that are proven to be useful at this point. Those are going to be considered covered countermeasures, which means there's going to be some liability limitations for manufacturers of those. That's not necessarily a direct change in how you're making some of these decisions, but there's some backside tax relief that's going to apply to it. Now, earlier I made reference to unemployment compensation. Just want to give you a little bit of a preview to what we're seeing on that, okay? Most states are suspending the waiting period for the payment of unemployment benefits. So typically, and it depends, it varies by state, but typically if someone suffers a loss of hours of work, they can apply for unemployment, and most states have a 2-week waiting period where no benefits are paid. Those are being waived, and most states are rolling back and saying you get benefits on day one, okay? Because of the nature of this virus, they're also waiving the in-person application requirements where those existed and work certs attestation requirements. So typically, if an individual was applying for unemployment, in a lot of jurisdictions, they still have to go into an unemployment office and do that in person. Every week, they have to send in a form or go online and say, we will look for work at a certain number of places this week in order to keep receiving benefits. For benefits that are relating to the coronavirus pandemic, they are waiving all of those requirements. A lot of states are also rolling out new procedures for the preparation of mass claims that have to be filed by employers that is intended to simplify and speed up the process. Next slide, and this is a little bit of a guess because this relates to the stimulus package, but what we are seeing right now is one of the things in the package is that anybody who is on unemployment is going to get a federal subsidy of up to $600 per week that lays on top of what the state would normally pay. For example, a lot of states have very low maximum benefits for unemployment, $250, $350, $375 per week. Under the stimulus package, what we're seeing right now is the federal government's going to drop $600 a week on top of that benefit. So somebody who, in the example I gave you here, if you're only able to get $362, that's going to make it really tough for a lot of people. Now that's going to get up to closer to $1,000. Hopefully will make life a little bit more bearable. Okay, next slide. One thing we have seen, and I haven't seen this in surrounding states, but we haven't looked at it fully. Georgia has developed a new employer portal filing requirement. If you have employees who are losing work based upon the COVID-19 situation, the employer has to go through an online portal, fill out a spreadsheet, and upload that. And if you do not do that, the DOL is going to require you to individually as an employer reimburse the full amount of benefits that are paid. Normally the benefits just come out of the kitty that is funded by the taxes that we all pay. They are putting a pretty stiff penalty on there to require employers to provide a more robust and easier to use level of information. Another thing I want to throw out on unemployment, for those of you who may not be laying off people fully or may have some people you're simply cutting their hours, in Georgia, any reduction in hours relating to COVID-19 means that the employer should be making a report to the state DOL that they've suffered some wage loss, and they may be able to receive some partial unemployment benefits to make up the shortfall. So unemployment does not apply only in the case of a total job loss. It also applies when there has been a reduction in hours. Georgia has taken the position that any work loss becomes a reportable event. Okay. Now, okay, what do we do with our retirement plans? In the face of this crisis, I can say we're kind of putting the future, that being our retirement, on hold. In 401k plans, employers may want to consider the reduction or elimination of any discretionary contributions that the employer makes. Generally, no amendments are going to be necessary for discretionary contributions. If your plan says the employer will contribute a certain amount, an amendment to that plan must be made. So be careful with how you do that. On the next slide, there may also be some relief in the stimulus package for safe harbor matches or non-elective contributions. All I can tell you right now is if you're going to mess around, and when I say mess around, if you're going to look to changes in how you're funding any form of retirement benefit, including 401k, talk to your benefits professional before doing that. We believe that the stimulus package is going to free up the manner in which that can be done, but please talk to your benefits professional. Our firm has a great team. Many of you probably have your own folks that you work with. Doesn't matter who you speak with, just make sure you speak with somebody who's paying close attention to that. Okay, next slide. Let's talk about health plans. One of the things that this statute does is it may have some impact on how health plans are paying for benefits. And as an employer, you need to be very careful about what your thresholds for insurance coverage are. For those of you who are rolling back hours for people, look at your plan documents, because if you roll somebody back past a certain minimum number of hours per week, that may be a triggering event for a loss of coverage under your benefit plan. A lot of benefit plans only cover employees who are full-time, and that may be defined anywhere from 20 to 30 or more hours per week. Every plan is going to be different. And if the employee drops below that, they may need to get a COBRA notice. Okay. Talk to your benefits folks. Consider whether you want to waive some of these eligibility criteria or even temporarily allow for work reduction schedules if you plan to keep benefits in place. We've got a number of clients who are laying people off but keeping their benefits in place, and we continually are reminding them, you need to look at your plan document and make sure you can do that. Okay, because if it's a third-party carrier, you're now violating plan terms. You may not be able to do that without carrier permission. So you need to talk to your insurers. If you're self-insured, you need to make sure your stop-loss carriers are on board, because the last thing you want to do is avoid or waive coverage. Okay, next. The statute imposed a very clear mandate that cost sharing is not going to be allowed for COVID-19 diagnostic testing and services, meaning no deductibles, no co-pays. The insurance plan is going to have to pay that full boat. It will have an impact likely on your premiums going forward, but employees are not to be bearing the burden of that if they have covered insurance. Okay. And as I mentioned before, the payroll tax credits to help pay for all this will include the cost that the employer is paying to maintain coverage for its employees who are on leave. Next slide. One of the things I talked about in terms of employer coverage on the enhanced FMLA or the emergency FMLA, the longer term, the extra 10 weeks for employees who have to be off work because of childcare needs, they may be able to apply if they have less than 50 employees for an exemption from that requirement. The DOL has stated that to get that exemption, and this is the only criteria that we know about right now, is the employer is going to have to show that providing the benefit would jeopardize the ability of the business to continue as a going concern. So it's a pretty high standard. If you're going to say you can't afford it, the DOL is going to ask you to prove that. So they're going to look at your overall financial condition and what the cost of $200 per day or 2/3 a regular rate would be. Okay. The DOL has said that this exemption will be determined on a simple and clear criteria basis. It's the DOL, so I can't really tell you what that's going to mean. I think they're going to look at financial documents in a very high level, but I'm not really certain. Okay. The next slide. The first thing that this statute is doing is taking a little bit of a vacation. That's actually good for everybody. Because of the compressed time frame that we're dealing with here, the DOL has stated that the first 30 days is going to be a period of non-enforcement. And that is, as long as you are acting in good faith, trying to comply with the materials that are out there, they are not going to come after employers for violating technical standards that may be set forth in later regulations. So when they say they're going to be in a period of non-enforcement, that's a non-enforcement with an asterisk. That asterisk meaning is you still have to comply with the types of things I'm talking about today. You can't simply ignore them. If you trip up a little bit along the way, they're not going to be seeking to impose any penalties or take any enforcement actions. Okay. That's a lot of material. I'm going to turn over for a few minutes to my colleague, Sarah Fay. Sarah is one of our corporate attorneys, and this departs a little bit from talking about employer leave. I'm going to be here at the end to handle some Q&A that Faze is going to moderate. But I wanted to have a few minutes for Sarah to talk about things that your business as a whole should be thinking about and doing right now, unrelated to leave issues. So with that, Sarah.
Thanks, Chris. Hopefully everyone can hear me okay.
Yes.
By way of brief introduction, I am an attorney in the corporate department of Miller & Martin. And I'm going to spend a few minutes talking to you more about some high-level housekeeping action items you should be doing now to mitigate potential adverse effects of the COVID-19 outbreak. Now, the reason Chris enlisted me to speak to you all today is because as a firm, our observation is that most businesses have been impacted to some extent by this outbreak already and are already running on limited resources. Despite this, we're seeing that many of the businesses out there still seem to be sitting back and reacting to COVID-related issues as they pop up, rather than proactively issue spotting and deploying resources as necessary. So I'm here to encourage everyone to get on the front foot and start deploying the resources you have available deliberately and strategically. So to this end, I'm going to talk through very briefly 4 action items that most every business can undertake now. First one is conduct internal due diligence. So if you can skip forward a slide for me. Perfect, thanks. Okay, conduct internal due diligence. There are a number of ways you can do this, but our experience shows that creating a catalogue of your material contracts and personnel is a really effective way to complete this exercise. If anyone on this call has ever conducted due diligence on a company they're looking to acquire or to purchase assets out of, you're already familiar with this process. For those who haven't, your goal here is essentially to create a central repository of key information about your business. It'll in turn expose areas where you have risk, and it'll reveal areas where you might have some flexibility, which you can then use to your advantage. So you definitely want to catalogue your material contracts. And for those contracts, at a minimum, you want to know your termination rights. You want to know your counterparty's termination rights. You want to know if there's any material adverse change or material adverse event clauses, if there's a force majeure clause, payment terms, and if there are any penalty terms or service level agreements that could bite you for as long as you are running on limited resources. You'll also identify which employees of yours you need to keep in place to keep these material contracts going. Most importantly, you should identify contracts and personnel that are critical to your business, identify if they're at risk, and deploy resources to mitigate those risks. Conversely, you might look to delay or terminate contracts you don't need or that are of low importance to your business. Look, at a minimum, you'd want to ensure that your limited resources aren't being used on low priority contracts. You want to make sure you're diverting the limited resources you have to your business critical items. Going back one slide. The second action item I have for you is to manage your cash flow. This goes without saying, but reducing costs and conserving your cash where you can is really important now. Stress test your cash flow assumptions for the upcoming months. And if you identify potential shortfalls, think about what cutbacks you can make now to delay the shortfalls, and think about whether you need to start engaging with potential funding sources now. Finally, whether you intend to rely on them or not at this stage, make sure you stay on top of the government assistance that is available to you now or that might become available to you. It's not enough just to know that, though. You also need to know the process for obtaining it and the timeframe for receiving it. Third action item I have for you is communicate with your stakeholders. Provide your employees, customers, shareholders, lenders, whoever else is out there who is important to your business with regular updates. they'll appreciate it, right? If furloughs, layoffs, shutdowns are happening in your business, communicate openly and timely with your staff. And your customers and suppliers want to know what you're doing to manage your operations, and they want to know what you're doing to keep everyone safe. Final action item for you is to implement or hopefully update your disaster mitigation and recovery plans. Your mitigation / continuity plan is basically your playbook to get you through this period. Whereas your recovery plan is the document you'll turn to get your business back to 100% when the time comes. What each of these look like will really be heavily dependent on your business, so I'm not going to spend much further on this. What I do want to say is that to the extent your business allows it, keep your mitigation plan, that first document, keep it balanced. And I mean balance current needs with your long-term goals. Otherwise, you might find that you struggle to rebound effectively and to implement your recovery plan, that second document, once the time comes. Make sure your mitigation plan will allow your recovery plan to succeed. So those are my 4 little action items for you. I'll turn it back to the hosts or Chris.
So I will send this PowerPoint around to everyone, but there's also some more information about Chris and Sarah if you would like to get in touch with them. And for the sake of time, I will choose a few questions here to pose to Chris and Sarah. So the first person, Janet Young, asked, what does full-time mean? Our associates are considered full-time at 30 hours. Will we need to compensate them for 60 or 80 hours to make them whole?
Okay, good question. Full-time, and I can only tell you what we know from the statute so far. I think they're worried really more about the other side. Full-time is going to be defined by what your regular pay is. So if the employee typically works for you 30 hours a week, your 2-week pay obligation is going to be total of 60 hours. If they work for you 45 hours a week, they're going to be capped at the 80 hours. All right. So it is worded in a way that looks at their regular pay. So they don't get an uptick or anything beyond what they would normally work in a 2-week period. They might get curtailed if they work more than 80 hours in a 2-week period. Hope that makes sense.
Gotcha. Another question Janet had is, what if we can offer work on the weekends if an associate has childcare issues and the associate refuses to work? Do they still qualify for the paid ER-FMLA?
Again, the regs may get around this or address this in a way, but typically we're going to be looking at what their regular work schedule is, as opposed to alternative work schedules you may offer them. And the reason for that is you may have some employees who would normally work for you 40 hours during the work week and then have a second job on the weekend. And the DOL is not going to require the employee to give up their second period of employment, to accommodate your schedule. Just bear in mind, there's an intended deterrent in this, in that on the child care side, they are only getting 2/3 of the regular pay, not the full pay. So some employees may, for financial reasons, may do everything they can to take whatever hours you can get them. You may have others that are would prefer, for different reasons, to just take the leave benefit. But I don't think you're going to be able to change their work hours unless that's something you normally would do in your work schedule. In a healthcare setting, for example, you have a lot of shift work, and not just in healthcare, manufacturing. If their normal work schedule would have them doing things on the weekend, then that probably is something that you could offer, and it would deprive the employee of the benefit. I can't tell you for certain on that though, and I'm more inclined to think that you can't push them to weekend work just based on the way the statute is worded.
Got it. And Bryn Warsh asked, do employees who decide to self-quarantine fall into any of the categories?
Well, if the employee is doing it for reasons other than a governmental or a medical directive, or they're sick, then no, they would not. If they just decide they're going to go into a cocoon because they're afraid of the outside world, then that's not going to be a triggering reason for any of the healthcare, individual, the paid sick leave part of it. They either need to be suffering those symptoms or have a doctor tell them to quarantine or a state health official tell them to quarantine. Now, realistically, it's not going to be hard to get a doctor to order that. All they have to do is, and they're going to figure this out pretty quick, is call their doctor and say, I'm not feeling well. And I think the default answer most physicians are giving is quarantine. Mm-hmm. Okay, Faze, if you don't mind, one of the questions I saw pop up was whether or not an employee can take the paid sick leave on 2 different occasions. Mm-hmm. And that is they have the symptoms, their doctor tells them to quarantine, they do that, they get paid sick leave, and then 2 weeks later, they actually do get COVID-19 and are sick for 2 weeks. The statute only provides 2 weeks of leave. So if there's a rebound or a second occasion in which they would qualify, if they've already taken their 2 weeks of benefit, that's all they get.
Got it. Being in effect April 1st, does that mean any cases prior will not be covered?
That is correct. That is correct. The statute does not impose any obligation on an employer until it becomes effective, and that date has been selected right now by DOL as April 1.
Okay.
A caveat I'll throw out is, and I don't have a wealth of information on this, there are some provisions in the new stimulus bill that are intended to encourage employers further to keep folks on payroll. As I roughly understand this, there's going to be some forgivable loans that employers are provided if they maintain their payroll size. I don't have further information on that, so I will just remind everybody, keep looking for materials on the stimulus package. That's not really a leave issue, but it might affect some of the payroll decisions you're making.
Mm-hmm. Question from Irene, counting employees within a company, how about joint ventures? Mother company, about 1K, joint company, 20 employees.
If you have common ownership, common management, they're generally going to be considered a related employer. The DOL, I think their regulations are probably going to drill down on this. This is a very interesting problem for lawyers because typically we are making arguments trying to say that the employer is smaller to avoid coverage under some of the existing statutes. And this is the first situation I've become aware of where we're going to be having to craft arguments to try to say that the employer is larger. What we have seen so far is the IRS at least is defaulting to an integrated employer scenario, which looks at common ownership, common control. I can't tell you much more than that because that's all we've seen.
2 more questions. Regarding Georgia DOL reporting the reduction in hour on the employee decision, would that still apply to the Georgia reporting?
Yeah, I saw that question. As I'm understanding it, yes. What we have seen in the DOL materials from the state of Georgia on this self-reporting for the employer process they had just implemented last week If there is any reduction in work as a result of COVID-19, they want the employer to report that. And that would be 1 hour of work, 5 hours of work, or all of the available work. I'm not sure if the question is asking if it's the employee has volunteered, but if there is a reduction in the amount of work that the employee is being asked to do as a result of COVID-19, the Georgia DOL wants the reporter, or wants the employer to report that through the employer portal.
We just got a question in. Can an employee be required to use their sick days or PTO before that to take advantage of the law provisions?
I believe the answer to that is going to be no. That the employee can invoke the leave anytime they want, and they're not going to be required to drain down other PTO first. We're still waiting to see the regulations as to whether some of the employers' policies concerning how days may be used can be manipulated around the leave requirements. But at this point, we believe that if the employee qualifies for leave under the statute, they get it from the minute they qualify. Another question that was there is, can the employee subsidize any salary differential with existing PTO leave bank dollars? I don't know for certain, but I think the answer to that is probably going to be a yes. So if an employee is capped at $200 and they normally would make $300, they would be able to pull their PTO accumulations to make up that differential. That's something I think that will be squarely addressed in the DOL regs, and our inclination is they can use it to supplement, but the employer can't force them to take it ahead of these leave obligations.
Gotcha. That's all the questions that we got in. So if any of you have one or two more questions, please ask. Otherwise, we can share Sarah and Chris's contact information, and you can get in touch with them directly.
Okay, Faze, I'd just like to tell everybody good luck. Be attentive. I hope you found this to be informative. It's a changing landscape. I don't like, as a lawyer, being in a position to not answer questions based on the wealth of knowledge that we have, but this is a new area. I think the government is trying very desperately to minimize the financial burden associated with this leave, but it is going to be somewhat disruptive to some of your operations and your decision-making processes. Thank you very much for your time. Thanks to Sarah for jumping in and pointing out some of these issues that I thought might be of interest to everybody. And we'd like to thank the German American Chamber for setting this up and giving us a forum to disseminate this information. Last plug is our website, millermartin.com, has got some additional resources that are being constantly updated by our various practice disciplines. And I think we'll probably have a lot more information on the stimulus package as it gets shaped up. So good luck to everybody. Be careful, be safe. Good time to get to know your family and pets.
Thank you very much for the presentation.
You're welcome. Thank you.
Thanks.
Thank you.